What's up everyone? Tonight we're going to speedrun LAW033 Chapter 1 and 2. Without further ado, let's go. Chapter 1, which will be Introduction to Legal Systems of the World. We must first know the definition, which will be the process or procedure of interpreting and enforcing the law. Moving on to the types of legal systems in the world, we will focus on Malaysia and we will focus on two lah senang cerita. We will focus on two, which will be civil and common. So civil, it places a significant emphasis of codified law by the legislature, and for common, law that uses the principle of stare decisis. So what is stare decisis? Stare decisis is basically judicial precedent. What is judicial precedent? Judicial precedent is the court rulings from similar past cases that have been brought into the case that we are currently going to proceed with. So beza dia adalah civil place a significant emphasis on codified law. It means that for civil courts, they will refer to the codified law such as in the federal constitution, the various acts, in order for the court to make verdicts. However, in common legal systems, they will heavily rely on judicial precedents to make their verdicts and also decisions lah, macam tu. We will now move on to the comparing and contrasting of common versus civil legal system. I will explain for common and I'll explain for civil. So for common, the judge role, there are three judge roles which will make rulings, interpret the law and set precedents. So all of these three roles are in other words a passive role held by the judge. So in the court there will be two roles which will be passive and active. So since the judge punya role is passive, the lawyers will obviously be active, in which they will present evidence, they will review the evidences, and then they will make arguments in favor of their side. Okay, so moving on to the type of argument for common legal system, it is an adversarial argument, which means that the lawyers will compete actively in persuading the judge and the juries on why their side is the better or the more logical side. Okay, for the presumption of innocence is the presumption of the defendant punya innocence, whether or not he is innocent or not at the beginning and throughout the case, throughout the trial. In the common legal system, they practice the term innocent until proven guilty, which means that throughout the proceeding or throughout the trial, the defendant is considered as someone who is innocent, and if there is substantial evidence that agrees to the fact that the defendant is guilty, then only the perspective will change and the defendant will now be considered guilty. Okay, in the common legal system, is the prosecutor's responsibility to prove the guilt of the defendant through the three stages which I will cover in chapter 2. Moving on to the trial of jury. Trial of jury is the jury adalah orang yang selalu duduk kat belakang, and they will usually make verdicts lah. They will represent the general public and they will make verdicts for the trial or the proceeding. In the common legal system, it is widely used, and itu sajalah untuk features and characteristics of the common legal system. The pros of the common legal system is its specificity, in which the judges will play a role in looking at the evidences, and then its consistency, since it uses the principle of stare decisis, the rulings will stay consistent until it is being overruled or changed by another court or another ruling. The third one is it refers to precedent in unforeseen circumstances. So dalam kes-kes yang sedikit kabur, kita boleh terus refer kepada presiden untuk selesaikan kes tersebut. Dan disebabkan diorang gunakan presiden ni yang telah digunakan secara lama, it makes up for its speed and efficiency. It's very fast and efficient in determining the rulings and verdicts of a court or a case based on the fact that it uses the principle of stare decisis. Moving on to the pros, however, the pros is its perpetuation of bad rulings. This means that once a bad ruling has been done by a particular court, it will now be considered as a stare decisis for future cases, and future cases will now refer to the bad ruling to make their verdict, and the perpetuation or the ulangan of the bad ruling will sentiasa berulang lah macam tu. And second one is over reliance on president. Kalau tak ada presiden, dia orang macam tak tahu nak buat apa sangat lah macam tu. Sebab dia terlalu rely kepada presiden yang telah di-establish. Kalau tak ada, tak tahu nak buat apa terus. And then it's need for records. So sebabkan stare decisis ni adalah court ruling daripada past cases, dia perlu record tau semua, each and every one of proceedings and trials in court. Jadi setiap trial tu kena di-record dan juga disimpan lah. Kalau tak ada, terus hilang. Okay, moving on to the civil. Civil punya characteristics. The judge role is more active, in which they will review the evidence, they will inquire for additional evidence if there is a lack of evidence being presented, and they will recommend a trial. So in the inquisitorial or in the civil punya legal system, there are two stages which will be the pre-trial and the trial. I will explain in the second chapter. So for the role of lawyers, they take on a more passive role, in which they will collaborate with the judge in the presentation of the evidence, and they will also, of course, submit the evidences to the judge. Okay, moving on to the argument. The argument in the civil legal system is more inquisitorial, in which the judge will take over and will handle most of the procedures in court. So we have established that in the common legal system, the argument is more adversarial, in which the lawyers will actively compete against each other. But in the civil legal system, it is in an inquisitorial system, in which the judge will take over the role of the lawyers set in the adversarial legal system. Okay, so the presumption of evidence is a little bit different from the common legal system in the civil legal system, in which during the pre-trial, which is the phase where the judge reviews the evidences, he will presume that the defendant is innocent. But when there is substantive evidence which will suggest that the defendant is guilty, he will then recommend a pre-trial. Now in the pre-trial, it is the responsibility of the defendant to prove that he is innocent. So dia ada dua stage. First stage tu adalah they consider defendant sebagai innocent. But if this evidence also agrees that the defendant is innocent, there will be no pre-trial. There will be no trial. So the trial will only be held if the defendant is found guilty based on the evidence brought upon by the lawyers. Okay. So the trial by jury is not practiced in the civil legal system due to the fact that the judge will make all the decisions and will control the flow of the case by himself. So there is no need for any juries to be present at the case. Some of the pros of civil legal system is that it is codified. So it is very clear and concise in its distribution and administration of law. In terms of the codified law, it is just senang untuk difahami because everything is written down clearly and concisely. And the second one is it's written simply and logical, so that the general public is also clear and can also understand the acts and the laws better. Third is it is really easy to read and understand, which is the same as the second one. And however, one of the cons for civil legal system is its rigidness. So rigidity or rigidness, tak tahu. So it's rigid. Maksudnya, which means that the law, which when it has been passed, it cannot be bended flexibly or dynamically to suit particular cases. We have seen that in this principle of stare decisis, that the precedent can be used and can be sort of molded into the appropriate situations. But in the civil legal system, the codified law is very rigid and cannot be molded or bended flexibly. And then it is also time consuming, as there are various and many acts and statutes in our country. So it is quite difficult to refer to each and every one of them when making a ruling. Okay. Moving on to a small subtopic in chapter 1, which is religious law, Sharia law, practiced in Malaysia and various other Arabic countries or Muslim countries. A few points about religious law. It stems from religious texts, which is the Quran, and the source of Sharia law, there are two, which will be the Quran and the Sunnah of Nabi Muhammad SAW. The nature of religious law, it is eternal, which means that it stands against time. Dia adalah boleh digunakan sepanjang zaman, from the beginning to the end of time. It is also immutable, meaning to say it cannot be changed by any human being. And disputes are settled by officers of religion instead of lawyers and also courts. It is settled by officers of religion, mainly ustaz, muftis and all that. And the punishment is a bit unique because it is the punishment of this world and also the hereafter. Okay, we are done with chapter 1. Now we're moving on to chapter 2, which will be systems of justice. Without further ado, let's go. So the system of justice punya definition is a system of law used to administer justice. The types of systems of justice, bear in mind chapter 2 is closely related to chapter 1, so there will be a lot of repeated terms and things that will be mentioned in chapter 2, which I have mentioned in chapter 1. The types of systems of justice will be adversarial and inquisitorial. So we have established that for adversarial, it is lawyer versus lawyer, but for inquisitorial, it is the sole responsibility of the judge. So we will now proceed as usual to comparing and contrasting between adversarial and inquisitorial. I will of course explain adversarial and then I will explain inquisitorial. In adversarial, the control of the progression of the case is the sole responsibility of the parties. So there are two parties to the case, which will be the plaintiff and also the defendant. So both lawyers from both parties will be responsible in moving and also progressing the case in the court. The judge punya role is more as a referee in the adversarial punya legal system, in a sense that they will keep the fairness of the case in check. They will also macam keep the lawyers in check if there are a few certain lawyers that step over the line in terms of delivery or in terms of emotional punya delivery. Dia macam judge akan beritahu lah macam sabar, yang berhormat, macam tu and all that lah. Okay, the lawyers punya role is more active, in which they present cases and arguments. They determine which evidence to show, which evidence not to show. Okay, this is important because as the lawyers in in the adversarial system, it is their duty to present the case and also present the case in which order they want. Maybe they want to present the evidence which holds a bigger weightage at the end, or they want to convince the judge and the juries awal, so they will present the evidence with more weightage in the beginning. So it's entirely up to them, and they also can choose whether or not to present the evidence which may discredit some of the explanations by their party. Contohnya kalau ada satu evidence ni yang didapati oleh plaintiff tapi dia lebih memihak pada defendant. So kalau lawyer daripada plaintiff ni nak present evidence tu, dia macam akan damage diorang punya argument. So lawyer daripada plaintiff ni boleh pilih sama ada untuk present evidence ni ataupun tidak. Kalau dia nak present, mungkin dia akan putar belikkan sikit supaya daripada dia favouring pada defendant, dia favouring pada plaintiff pula, macam tu. So it's entirely up to them, because it's their active role as the lawyers in the adversarial system. The verdict will be reached by the jury, mainly by jury. If the trial is held with a jury, a council ataupun a line of juries belakang, the verdict will be reached by the jury by majority decision. But if there is no jury at the back of the court and the trial is held without a jury, it is the responsibility of the judge to reach the verdict by himself. Okay, so there are three processes in the adversarial system, which will be examination in chief, cross-examination and re-examination. First one, examination in chief. This is the part where all witnesses will give their testimonies that they have written earlier in the form of verbal punya testimony, and this is to give evidence to one particular party. Contohnya, for example, the plaintiff will tampilkan the witness for their party. So the witness will present their evidences in the form of verbal testimony, and the evidence or the testimony is the same as the one they have written down earlier. In their case, dalam waktu diorang tengah being interrogated lah. Okay, second step in the process in the adversarial system is cross-examination. This is where the lawyers or the adversary ataupun the opposing party will have the chance to ask the witness a few questions regarding their testimony. Now, what is this for? This is to discredit or to remove or to lower or to reduce the credibility of the witness as the sebagai witness of the case. Jadi dia macam plaintiff dah bagi witness and witness tu dah bagi testimoni. Sekarang defendant tu akan tanya witness kepada plaintiff tu beberapa soalan tentang diorang punya testimoni lah. Jadi ini adalah untuk melemahkan testimoni daripada witness pihak plaintiff ni, macam tu. Okay, the third and final step in the process of the adversarial system is re-examination. Now, re-examination is where the lawyer from the previous party who has presented their witness, they will recheck and also restate some of the questions that have been addressed by the adversaries, and the only matters that could be brought up in this stage are matters which have been asked by the adversary party. There will be no matters that could be brought up outside of the ones that have been addressed by the adversary without the permission of the judge. Jadi dia ada tiga. Dalam PM dia ada tiga lah. First adalah examination in chief. Witness akan bagi testimoni mereka dalam form of verbal testimony. Second, cross examination. Pihak bertentangan akan tanya witness kita ni sama ada pihak bertentangan akan tanya witness kita untuk discredit ataupun disprove testimoni mereka untuk melemahkan argument daripada pihak kita. Okay, third, re-examination. Re-examination adalah apabila pihak kita yang akan address balik soalan-soalan yang ditujukan kepada kita, dan hanya soalan-soalan yang ditujukan kepada kita sahaja yang kita boleh address dalam part re-examination ni. Tak ada benda-benda lain yang kita boleh cakap ataupun kita boleh bangkitkan dalam stage ini. Okay, we are done with the adversarial. We'll move on with the inquisitorial. Inquisitorial, for the control is solely upon the judge. The judge will control the case punya progression. The judge role is to act as an investigator in which he asks for evidence, he values the evidence and he reviews the evidence. He can also ask for more evidence if he sees it as not enough. Okay, the lawyer's role is more passive compared to the active role of the judge in the inquisitorial system, in which they collaborate with the judge in the presentation of the evidence brought upon by them. Okay, the verdict will be reached solely by the judge, since the inquisitorial system does not practice trial with juries, and the process is the pre-trial and the trial. So in the pre-trial, the lawyers will present their evidence and the judge will review the evidences. He will evaluate whether the evidence is enough or not, and if there is an insufficient amount of evidence, he can inquire for more, and the lawyers may take up from days to months to years to come up with the new evidences that the judge has asked for. So in this pre-trial punya stage, if the judge has found that there is substantive evidence that may suggest that the defendant is guilty, he will recommend a trial. The trial is to prove, once again, the trial is the chance for the defendant to defend themselves and prove their innocence because the because the presumption of innocence has shifted from innocent until proven guilty to guilty until proven innocent. So in the pre-trial, the presumption of innocent until proven guilty is practiced, but in the trial, the later stage of the inquisitorial system, they will practice guilty until proven innocent. Okay. So that is it for adversarial versus inquisitorial system. We will move on to types of litigation. There will be two, which will be civil and criminal. So the differences between these are civil cases, civil litigations, they will settle disputes between individuals, but in criminal litigations, they will they will settle offences by an individual versus a state. So in the parties of civil litigation, it is the plaintiff and the defendant. The plaintiff is the one who initiates the case, and the defendant is the one who is being accused on. For criminal, there will be two parties to the suit as well, which will be public prosecutor, which will represent the state in prosecuting the accused person. So the second party to the suit will be the accused person. Okay, the civil purpose is to compensate plaintiff. So the civil litigation punya purpose is to compensate the plaintiff for the damages that they have incurred. However, for the criminal litigation, its purpose is to punish the wrongdoer and act as a pengajaran kepada orang lain. Okay, macam tu. Moving on to the preliminary matters for a case. These are what we require or what we have to have before initiating a case to the court. So, the first preliminary matter will be parties to the suit. We have established just now that there are two parties to the suit, both in civil and criminal. The civil will be plaintiff versus defendant. So, in the civil litigation, there will be two parties for two different suits, and the first party will be plaintiff, the second will be defendant. The plaintiff, like I said, is the one who initiates the case. The defendant is the one who has to defend themselves. So, in the case of the defendant appealing to the court for their innocence, now the defendant will be the one initiating a new case because they have appealed for their innocence to the court. So now the defendant will initiate the case and they will be called the appellant, and the plaintiff will change to the respondent. So dalam civil litigation ni, dua-dua parti ni boleh jadi antara yang menginitiate case ataupun yang mendefend diri mereka, macam tu. Okay, for the criminal litigation, in preliminary matters, there will be two parties as well, which will be the public prosecutor, which will be representing the state in prosecuting the accused person, and of course the accused person, which will defend themselves, prove their innocence in the face of the court. In our pembelajaran, we will only focus on civil litigations. Okay, a few conditions for the parties to fulfill in order to become a legitimate party to the suit will be two. There will be two, which is sui juris and compos mentis. Sui juris means the age of the majority, and in Malaysia it is determined to be the age of majority. In Malaysia, the age of majority has been determined to be 18 and above. So the first one is sui juris, which is 18 and above, and compos mentis. Compos mentis means both of the parties must be in rational thinking. They can think for themselves naturally, and they are in a healthy state of mind. Okay, moving on to the second preliminary matter, which will be locus standi. Locus standi, in the eyes of the law, the definition has four parts. The first is the right to appear. Second is to bring action. Third is to be heard in court, and the fourth is to address the court in a matter. So, for a plaintiff to initiate the case, he must fulfill either one of these four locus standi. So he either has the right to appear, or to bring action, or to be heard in court, or to address the court in a matter. If he doesn't have to fulfill all four, it is enough to fulfill only one of these four. Okay, for the plaintiff competency test, what makes the plaintiff layak untuk initiate case tu dekat court? So he must have two things. He must be adversely affected, meaning to say the case must negatively affect the party in one way or another. And the second one is that they must show real and genuine interest. It basically says that how does the plaintiff be related to the case in some way. So maybe kita ni adalah anak kepada kita ni adalah bapa kepada anak kita yang mungkin dah tercedera waktu dia pergi lawatan sekolah. So kita sebagai ayah kepada budak tu, kita ada real and genuine interest. Dari segi real and genuine interest tu adalah kita adalah ayah kepada anak kita yang tercedera dekat sekolah, dekat lawatan sekolah tu. Secondly, kita punya adversely affected tu adalah kita punya anak ni tercedera dekat lawatan sekolah dia. So kita kena bayar for his medical bills and so on and so forth. So these two must be fulfilled by the plaintiff in order for them to bring the case to the court. Okay, one case of a locus standi which is invalid, it was in the case of the Malaysian Trades Union Congress versus the government of Malaysia in 2014, in which the MTUC, which is the Malaysian Trades Union Congress, they have requested for the Syabas punya documents concerning the increase in water tarif, and it was rejected by the minister in charge. This was due to the fact that the Malaysian Trades Union Congress does not have any real and genuine interest to the case. Therefore, the lawsuit or the case cannot be proceeded into the court. Macam tu lah. So kita kena ada real and genuine interest. Kita mesti adversely affected dekat case tu juga. Macam tu. Okay, third preliminary matter will be cause of action. Cause of action, by definition, there will be a lot of definitions, but we will refer to the definition in the case of Lim Kian versus Chun Kun in 1970. The court has said that a cause of action normally accrues when there is a person who can sue and another person who can be sued, and when all facts which are material to be proved to entitle the plaintiff to succeed have happened. Basically, summed up, cause of action is the reason why the plaintiff can initiate the case to the court. But one important detail that must be fulfilled is that the cause of action must be completed in order for the plaintiff to initiate a case in court. So, one case that has an incomplete cause of action was in the case of Seo Kun Lin versus SB Mehra in 1981, in which the plaintiff commenced an action for recovery of arrears that were in fact not yet due at the time of the claim, and the plaintiff has no cause of action since the debt was not due. Okay, senang ceritalah dalam BM. Saya ada agreement untuk bayar RM500 dalam masa 3 bulan kepada kawan saya. Jadi kawan saya ni sebelum 3 bulan tu dah habis, dia dah initiate case kepada court yang mengatakan saya tak bayar pun RM500 dia dalam masa 3 bulan tu. Tapi isu dia sekarang ni 3 bulan tu belum habis. Jadi dia tak ada cause of action yang dah complete sebab 3 bulan yang dah dipersetujui dalam kontrak kami tu belum tamat lagi. Jadi saya masih ada masa untuk bayar dan dia masih kena tunggu sehingga 3 bulan tu selesai, baru dia boleh ada cause of action yang plausible untuk dia bawa kes kepada court. Okay, there are two types of causes of action, which will be breach of contract and negligence. So for these two causes of actions, we must ask 3 questions. First, for the breach of contract, the first question will be, what's the contract? What is the contract between the plaintiff and the defendant? Second question, what is the breach? What is the breach of contract that has been done by the defendant that will entitle a plaintiff to proceed in court? And the third question is, what is the loss that has been incurred by the plaintiff as a result of the breach of contract by the defendant? So that will be for breach of contract. For negligence, 3 questions as well. First, the relationship between plaintiff and defendant. For example, macam tadika tadi, saya sebagai plaintiff adalah bapa kepada anak saya yang belajar di sekolah tadika lah, yang belajar di tadika defendant saya, macam tu. The second one is the breach of care duty. What has the defendant done to breach the care duty that has been obligated and imposed to them? The third one is the loss of the injury. As a result of the breach of care, what injury has the plaintiff incurred as a result of the breach of care? Macam tu. Jadi 3 soalan untuk 2 jenis cause of action yang berbeza. Okay, fourth will be limitation period. Limitation period can be defined as the period within which the suit must be brought to the court. So this is tied to the cause of action. Once the cause of action is done, we have a certain amount of time called the limitation period to proceed in court for the action or the case that we want to present. So there are 3 types of limitation period. First, if the action falls under tort and contracts, we have 6 years from the completed cause of action. For example, if a contract was breached today, which is hari ni berapa bulan? Which is the 3rd of March 2024, the limitation period ends on the 5th of March 2030. Macam tu. Kita ada 6 tahun selepas cause of action complete. Okay, second, dependency claim. For dependency claim, limitation period will be 3 years after the person's death. After the person has died, we have 3 years from the date of the death of the person. Third, if the limitation period is an action against public authority, basically we are complaining on the public authority misusing their powers, we have 3 years after the wrongful act. If the act was done today, we have 3 years from today to commence a complaint or to commence a case to the court. Okay. Last but not least, the last preliminary matter, the 5th preliminary matter will be damages. Damages are what the plaintiff can be entitled for when they proceed their case in the court. There are 4 types of damage. Let me rewind that. The 5th and final preliminary matter for chapter 2 will be remedies. Remedies are what a plaintiff is entitled to when they proceed their case to the court. There are 4 types which will be damages. Damages is in the form of money. If I have lost 500 ringgit as a result of breach of contract from my friend, I am entitled to a damages punya remedy of 500 ringgit, macam tu. Apa yang kita rugi, kita akan dapat balik in the form of damages, macam tu. Second is rescission of contract. Rescission of contract is basically the cancellation of a contract between 2 parties. Third will be specific performance. Specific performance is an order from the court for a specific act to be done. Contohnya, saya komplain kepada court yang jiran saya tak potong rumput. So rumput dia dah jadi macam pokok dah. Dia tinggi macam pokok, dia masuk ke rumah saya. Jadi saya bawa kes tu ke mahkamah dan mahkamah boleh arahkan jiran saya untuk tebang rumput dia supaya tak mengganggu saya, macam tu. And the 4th and last remedy will be injunction. Injunction is more or less like specific performance, but it is more on the order of a court for an action to be done or not be done. Jadi antara kita boleh buat, antara court order seseorang ataupun satu parti tu untuk buat sesuatu, ataupun court dia bagi tahu ataupun dia mengarahkan satu parti tu untuk tidak buat sesuatu, macam tu. So that's it. 34 minutes, 2 chapters for Law 033. I will see you all in the next video. Bye bye.